everybody. I wanted to do one more quick one today because it's just so good. I have three that I really love. It's not as good as the last video I posted because she was a Karen. And Karens are my favorite. But this first guy gets freaking close. He's not a Karen, but he gets close. Second guy is so funny, asking for something he will never get, ever. And the third guy is the reason why I'm doing one more today, because you just can't smoke weed in the jail lobby and not get a YouTube video. It's just not possible. So I'm gonna play these. So I was told in the last video that my microphone was way too loud and then the court was way too soft. So this is try 3 of trying to even that out. So no matter how this turns out, I'm just uploading it because I've been trying to get this video all day. But it's fun. It's a fun video. So I hope you enjoy it as much as I do. Hopefully in 2 seconds my intro plays and it doesn't blow your speakers out. Hopefully I even that out, but we're about to find out. And if you like what you see, I did. I thought these were great. But if you like what you see, hit like and subscribe. It really, really helps.
Sir.
I love this judge. I love this judge. I hear the comments people make about her, but I love watching this judge. She makes me happy. This guy wants to be in control. The judge is running it, but the real person in control is that woman standing behind the bailiff. With ponytail and white sleeves. It's a prosecutor. And they've already done this man a solid. And, you know, it was all decided. It was all done. And he's like, nah, I don't like it. Try again.
Yes. Okay, this is the People versus Mark Nozel. Can I get your appearance, counsel?
Yes, Neely Donna for the City of Taylor.
Mr. Nozel, can you tell me your name, please?
Yes, Mark Nozel.
All right, so there was a default judgment entered against Mr. Nozel. He appeared in court and indicated he didn't think he should have to pay for the ticket. I told him that there was an appropriate form to file if he wanted to set aside a default judgment. He filed that paperwork with the court shortly thereafter, and I did grant his motion, so the default has been set aside. Ms. Zelnick?
Yes, so we're going to adjourn this for a formal hearing. I did speak with the city prosecutor, Matthew Zick, for Taylor on this case. He just told me to advise the court that the charge for the formal hearing at the next court date will be amended to 16 to 20 over.
So just in case you didn't understand that, it was double parking, which is 0 points. And he said, no, I don't like that. So she just amended it back to the original, which is 16 to 20 over.
All right, Mr. Nozel, do you understand that?
No, he does not.
That it's going to be renegotiated?
Well, no, it's not renegotiated, sir. The ticket was originally written as a double parking, the default ticket. But I assume, I'm going to look at the ticket. It states on the ticket, sir, which I can only assume you have a copy of. Double parking 165, 0 points. On driving record 53 and a 35 at 621 feet in a construction zone. So they're moving to amend the ticket back to the non-reduced charge of the speeding in a construction zone. Is it 16 to 20 over, or is it, hold on. And that would have been 53 and a 35. So yeah, So the allegation is going to be that you were doing 16 to 20 over in a construction zone. That's a 4-point ticket. So they're going to move to amend to that.
Well, that's what Ms. Zelnick informed me that I needed to do in order to negotiate my position on the ticket. Since I was given the impression it was negotiable when he negotiated double parking, but if I'm misinformed, then I'll just go from there.
I told the defendant that he could pay the double parking. That was all that was being offered, or we'd have to set it for a formal hearing. And I advised him as to the charge being amended at the formal hearing.
So it was already, the prosecutor's position is that it was already reduced down when it was written as a double parking instead of the 15 to 20 over. So if they're having a formal hearing, the prosecutor is stating that it's going to be amended to the 16 to 20 over for the formal hearing.
So if that means that I'm going to get to talk to the officer and explain my position on it, and if he could reduce it to a double parking based on my good record, accelerating out into a construction zone where there's no speed limit posted, that possibly I could have been reduced to like a parking ticket or a failure to wear my seatbelt.
Well, they already gave you the double parking.
Yeah, but I would have wanted to reduce it to something less than that.
But there's really not much less than that.
Parking ticket?
For a city ticket, a double parking is a 0-point infraction. I don't know what else they would reduce. That's not my place. That's the prosecutor and the officer's place. But well, generally,
I could be wrong, but I would think a parking ticket is much more reduced than a double parking ticket.
Well, we don't, there has to be an ordinance that complies, sir, and I'm not aware of one.
An ordinance that complies to what?
There has to be a city ordinance for that type of case. So for them to reduce it to a parking, there would have to be a parking ordinance. There's a double parking ordinance.
Oh, they don't have parking ordinances?
Not to my knowledge.
Did they have failure to wear a seatbelt?
The prosecution is just going to offer the reduced charge, which is what we told the defendant, that it would be the double parking, and we discussed that was reduced at the time. So we are offering the double parking, and if you want to pay that, we have no problem with that. The default was set aside, and that was granted, but that's all that we are offering at this time is the double parking.
Wait, you mean he can't just pick? He can't just pick what he wants to be his ticket? This is ridiculous.
So when's the court date?
You'll get it in the mail, sir.
Thank you.
So to be amended to 16 to 20 over, it'll be set for a formal hearing, and you'll get notice of that date in the mail.
Will I be offered legal?
It's a civil infraction, sir. You're not given.
Well, I'm confused because they sent that to me in the mail, and I had a right to do
that. The only way you get counsel and have a constitutional right to counsel is generally if it's a misdemeanor or there's a possibility of jail time. And there's no possibility of jail time on a civil infraction, so you wouldn't be entitled to a free attorney or but you can retain attorney, certainly.
Does the court offer me one?
I don't have an attorney for you. I can't give. What are you confused about, Mr. Nozel? I just explained to you. You do not have a constitutional right to an attorney because this is a civil infraction and there is no possibility of jail time.
Well, I'm trying to clear up your confusion by getting my paperwork out here. I had it.
Judge, he was sent a letter from somebody, but he doesn't know who, that told him that he could go get a lawyer. So he assumes that means you have to give him a free one and a parking ticket, please.
Offered to retain an attorney. So I'm confused. Would you understand why I would be confused?
No.
When the offer was made to me to call one?
I don't have anything about offering you to retain an attorney.
I got a letter to call an attorney from the city of Taylor that I would have the right to an attorney. That's the confusion. Can I be any more clear?
Sir, I don't know who you think you're talking to, but I'm not going to have you snapping at me and could you be any more clear? I've indicated to you it is a civil infraction. You do not have a constitutional right to an appointed attorney. I don't know what paperwork you received from the city of Taylor or from the prosecutor in the city of Taylor, but you received nothing from the court offering you a free attorney, as you refer to them as, because you don't have a constitutional right to one. There's no possibility of jail time.
With all due respect, I wasn't snapping, but it sure sounds like you're snapping.
All right, we're done here today. You'll get notice of the date in the mail. If you want to retain an attorney, you're free to do so, Mr. Nozel.
Thank you. Have a nice day.
So, if I ruled the world, that man would get 16 to 20 over the speed limit in a construction zone. And there is no way I would amend that. No way. He dismissed it. He set it aside. He said, no, I don't want that. Okay, fine. We're going to do exactly what you want. And we're going to try this because you want the jury. You want the court date. You got the court date. I don't know where the prosecutor is right now, but oh my gosh, that man, he drove me crazy. He had everything and he just wasn't enough. I don't know what would be enough to satisfy that man. I just have no idea. I'm just dumbfounded.
What's your name?
And now I'm going to be even more dumbfounded because at least the last guy, idiot, asked for something that was, I guess, semi sort of possible in the realm of possibilities. This guy has a request that it's so funny.
I can't hear you.
Speak a little louder. My name is Terrence.
All right. Mr. Samuels, I'm Judge Pitts. I'm going to give you some information before I go any further. You're here for a first appearance, which means you're here for me to inform you of your charges, set your bond, and give you your next court date. You also have the right to an attorney. If you cannot afford one may be appointed to represent you. There is an so you already filled out the application?
Yeah, ma'am.
Okay. All right. Well, you also have the right to a trial. At your trial, you have the right to see, hear, and cross-examine any witnesses that the city may bring to testify against you. You have the right to bring your own witnesses. Excuse me. And you have the right to testify on your own behalf. You also have the absolute right to remain silent and to know that your silence will not be held against you. And lastly, you have a right to a first appearance or probable cause hearing. At that hearing, the officer will be present, possibly any victims or witnesses. Everyone will have a chance to be heard, and the court at that time will determine whether it's more likely than not first of all, whether a crime was committed and whether it's more likely than not that you are the person who committed the crime. If the court finds that there is probable cause, the case moves to the next step. There is no probable cause, the charges are dismissed. Looks like you're here for disorderly conduct under the influence. There is already a warrant on this case as well. It looks like you were just recently here for something similar. Your bond amount is $1,000. Will you be able to post bond?
No.
And you've said you've already asked for an attorney?
Yeah.
All right. Once the application is reviewed and determined whether you qualify, the attorney, if you qualify, the attorney will come and speak with you prior to court. You'll be brought back out on Wednesday. All right. Do you have any questions?
Was the bond,
1,000.
you said court back on Wednesday?
That's correct.
What's the charges?
Disorderly conduct under the influence. Any other questions?
That's it? That's the only one?
That's the only one I see. Let me double check to see if you have something else.
Okay. Listen, for everybody out there, if you're ever in court and the judge just tells you what your bond is and everything, never, ever, ever, ever ask her to go double check to see if you might have other charges that she didn't previously know about, because now this woman knows.
Looks like you have another open case of obstruction.
Sure does.
That may, let's see. One moment. That looks like it might have a failure to appear on it. That's from March of 2022. That's when you have stay away from East Point until the case is closed, and that case is still open. Or that case is still open. So you do have another old case that's still pending. All right, any questions?
Yeah, I need a knife.
Excuse me?
I need a knife for every cell I go into. I need a knife.
You need a what?
Weapon.
All right. Mr. Samuels, you're not going to receive any weapons.
Rude.
So unless you have any questions about court, you can step back and let the next person come in.
Judge, come on. Be nice. He needs a weapon. Jail is hard. Jail is hard. Give him a weapon, Judge, and give that last person a parking ticket. Why is everybody being just so mean today?
Go ahead. Don't close that door all the way.
You all heard that, right?
Ma'am.
You heard what he asked for?
Yes, ma'am.
Okay.
A failure to appear in possession of marijuana less than an ounce, stemming from.
Okay, this last guy he's not as funny as the other two, but what he did was hilarious. So, and there's a couple little things in here that's hilarious. So he's the reason why I'm doing this today.
The November 18th, 2019 incident, as well as a new charge under June 28th, 2023, in or about a location for disorderly conduct. There's an allegation that the subject possessed and smoked marijuana in the jail lobby.
In the jail lobby. In the jail lobby. But don't worry. It was an accident.
And that is correct, Your Honor. And I represent Mr. Griggs.
All right. Any announcements on Mr. Griggs?
Yes, Your Honor. He did wish to enter a plea today. I was able to speak with him at the jail last week on Friday. He did indicate at that time that he wished to enter guilty pleas on all charges, Your Honor. He's been in, I believe, 5 days now, well, since the 28th.
All right, thank you. And I'll review his history in line with that. But he does need to understand that even if he's been in jail for 5 days, that doesn't mean that he may not get more jail time.
He understands that, Your Honor. I explained that to him.
All right, thank you. Mr. Griggs, if you enter a plea on today, you're giving up the right to a trial before this court, the right to hear and cross-examine witnesses called to testify against you, the right to remain silent and not incriminate yourself, as well as the right to have the city prove its case against you beyond a reasonable doubt. You also have the right to subpoena witnesses and evidence for court, and by entering a plea of guilty or nolo contendere, you in fact waive those rights. You also give up the right to an appeal to the Superior Court of Fulton County. Can you raise your right hand for me, please? You swear or affirm the information you give is the truth under penalty of perjury?
Yes, ma'am.
You can lower your hand. Did you hear and understand the legal rights I went over?
Yes, ma'am.
Do you have any questions regarding those rights?
No, ma'am.
Has anyone forced you to waive them?
No, ma'am.
Are you satisfied with the representation that you've received from Mr. Dabney on today?
Yes, ma'am.
And are you entering a plea of guilty, not
Yes.
guilty?
Yes, ma'am.
Which one, sir?
Guilty. I mean, guilty.
All right. Has anyone forced you to plead guilty?
No, ma'am.
All right. Thank you. While I'm reviewing the history, Mr. Dabney, any argument?
Just very briefly, Your Honor. He is here to admit to the allegations. He is here to answer to the charges, Your Honor, and accepts full responsibility for those charges. Would just like the court just to take consideration in the amount of time that he's been in, and to give him credit for that on any charges that he's eligible to get time served on. And he has no issue with a fine or probation, Your Honor.
All right, remember that. He's here to take full accountability of his actions. And he's okay with, a fine or probation.
All right. My concern, counsel, is he has 50 cycles.
Yep. You heard her. She did not stutter. He has 50 cycles, not 15. 50 cycles. He has 50 cycles. And this one is smoking weed in the jail lobby, which, by the way, in Georgia is still illegal.
And I need to know why he chose to smoke marijuana in the jail lobby.
Mr. Griggs, answer just that question only, okay?
Yes. Ma'am, I thought I put it out, ma'am, and it was still smoking when I came in. So that's the only thing. I had my jacket pocket, I had cuffed it, and I thought I put it out, ma'am, but I wouldn't try to smoke it out.
That was my bad, Judge.
Apologize for having it. I came and talked about some property that I had left before I went out of town, and then they seemed to smoke it. They blew a big deal, and they rushed me in with the talking like I was disrespecting the jail. That's all.
She's speechless.
Counsel, where does your client live?
Mr. Griggs, where he's currently staying?
49 Akron Street, East Point.
East Point, Your Honor.
Employed or unemployed?
11 Peace Movers in Doraville. Oh, excuse me, I'm supposed to talk.
No.
I mean, you can the judge just wanted to know whether or not you were employed or not, Mr. Griggs.
Yes, ma'am. I work at 11 Peace Movers in Doraville.
Right, Attorney Dabney, will your client be signing the plea form or will you be signing on his behalf?
Mr. Griggs, do you give me permission to sign the plea form on your behalf, or did you want to sign it?
You can do it, sir.
Okay, I accept that responsibility, Your Honor.
The sentence is going to be 6 months to serve 10 days, credit for time served that he's been here. He'll be on mandatory minimum probation for the remaining period of time of that 6 months with random drug and alcohol screens. He'll be required to do 60 hours of community service and a $500 fine. That includes the state surcharges. Understood, Mr. Golston?
Yes, ma'am. If you could tell me his name again, please.
Marcus Griggs.
Griggs.
And that is on the in or about location with the drugs. Now, Mr. Dabney, he also has a possession of marijuana less than an ounce and a failure to appear.
Yes, Your Honor. He is wishing to enter guilty pleas on those as well, Your Honor.
Is that correct, sir?
Yes, ma'am.
And how long has he been in custody?
He's been in since June 28th, Your Honor.
And FTA will be time served.
Thank you.
The possession of marijuana less than an ounce will carry a fine of $705. They will still have the random drug and alcohol screens. This will run consecutive to the other charge. That probation period will be for 12 months, 6 of which will be a mandatory minimum. So we have a total of 12 months mandatory probation. They'll be required to do a drug and alcohol evaluation and treatment if necessary. On the state charge. Understood.
Understood, Your Honor.
Do you understand, Mr. Griggs?
Can you just run it back one more time, everything?
Certainly. On the older charge, you have 12 months probation, mandatory minimum of 6 months on that probation, which will run consecutive with the new charge. You'll be required to take a drug and alcohol evaluation and get treatment if they deem it necessary. You'll be subject to random drug and alcohol screens during that time and must not have any positive screens. You understand?
Yes, ma'am.
The failure to appear will be time served, so there's no additional jail time on that. On the newer charge, you do have 6 months to serve 10 days. You'll get credit for the amount of days that you have been in custody. After the 10 days has gone, you'll be on probation for the remaining, and that will run consecutive. So that the total amount of time you have is 12 months, less the 5 days or the 10 days that you serve on probation. Do you understand?
Yes, ma'am. So what I have 5 more days?
If that's what the jail says. Once she reports it over, they'll calculate it based on when you came in.
Yes, ma'am.
Any questions?
No, ma'am.
Your Honor, did you originally say you had 60 hours of community service?
Thank you, I did. 60 hours of community service, Mr. Griggs, on the newer charge.
Okay.
Mm-hmm. And then the $500 fine.
And the $500 fine.
John,
Yes.
if I can pay the $500 fine, will I be off probation?
No, sir. That's what mandatory minimum means. Because you have 50 cases out there, 50 cycles. And most of them have happened at East Point. And I don't know whether that behavior has been arrested before, but I need to make sure that we at least see if we can get you some treatment and hold you on the line for a little bit longer to make sure you stay out of trouble. Seems like you tried and then all of a sudden you just went left. All right, so we got to get back on track.
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
Mm-hmm.
So fun fact, if you have 50 cycles in Georgia and you walk in to the jail lobby and you smoke a little weed by accident, you're going to get 5 days in jail. So you better mind your P's and Q's, people. I don't know why the judges were so mean today. I don't know why they just didn't give everybody what they need to survive. It's like everybody's out to get these inmates. Ugh. Oh, it was funny. It was funny. Oh my gosh. I wonder what goes through their head when they're asking for some of this stuff. Like, does that really seem like a really good idea right now to ask the judge for a knife? that's going to help me? Is that going to get me further towards my goal or further away from my goal? I wonder. I guess if your whole goal is to get a knife, then that's fine for you then, right? Well, guys, I don't know if you heard a little bit of fireworks going on in the background because everybody here is celebrating. Tomorrow's the 4th of July, and I hope you and your families have a great 4th of July. Celebrate a little bit. It's been rough lately, And if you enjoyed the videos like I did, hit like and subscribe. It really helps. Thanks, guys. Have a great holiday.